So in this video, I'm going to answer the latest questions that you've got on Lucy Letby and a few other subjects as well, but obviously mainly Lucy Letby, that's the subject of the channel. So I haven't saved every single question this time because I realised I hadn't done one for a while and I don't know how long this is going to take, so I'll just get through them as quickly as I can. So without further ado, the first question is, are you going to do a live stream? The answer to this question is yes, I will do a live stream at some point. I intended to do one before now, and I would like to test the water and see how they go. I was on Mark Mays' live stream recently. That wasn't planned, it just happened to occur. I am planning to do one. I don't know when it will be. I've just been extraordinarily busy. Obviously, I've been recording for YouTube and making new videos for YouTube, but also I've been doing stuff related to my book. I've been doing campaigning stuff. I've been doing organisational stuff. I receive a lot of correspondence now. I still have to do research and reading. Obviously, I've interviewed people. So I am actually quite tired, to be fair. But I just need to keep going until there's a bit of a parting of the river, and at some point it'll get a little bit easier. It's just in the moment I'd love to be able to just concentrate on doing YouTube and then have more downtime when I'm not doing it, but unfortunately that hasn't been possible, and all these things that I've been doing are really important. I'm doing something really important now that people don't know about that's hopefully going to work out. If it works out, it'll be really big. There's other stuff I've done. Most things you try and do don't work out. Either they can't be progressed or there's legal problems, all kinds of stuff that you don't know about that I've done that just ended up in a dead end. But if there's anything that comes up, I will always do it for Lucy's benefit, and because I know we need to do everything we possibly can while the opportunity presents itself. So I have been doing a lot of stuff, and therefore when I planned to do my previous live stream, I just didn't really have the energy to do it. I just thought I'll leave it for a later date. But I will do one at some point. And hopefully I want to have guests on as well. But that's planned. Maybe it's even imminent, but I don't know what date it'll be, but it'll happen eventually. Would you consider having a Patreon? So a lot of people have asked me this, and it's really nice to be asked that in a way. I guess it's under review, but I don't have any plans to have one currently. I'm obviously had a lot of support for the channel. I'm really happy about that, and I'm perfectly okay as I am now. If I feel that it's justified for me to do that, or if I feel it's going to be helpful for me to do that, then I will consider it at that time. At this point in time, I don't have any immediate plans to have a Patreon. Would you interview someone who believes that Lucy Letby is guilty? Yes, I would. I'd be perfectly happy to do that. The problem that you have is that there isn't anyone credible who believes that Lucy Letby is guilty. So you've seen the calibre of people that I've had on who share my perspective. There isn't anyone of that calibre who believes that Lucy Letby is guilty. There isn't anyone of any decent calibre at all. In fact, everyone that's come forward to comment on this case believes that Lucy Letby is not guilty, or believes that this is an unsafe conviction, or believes that there are serious problems with the court case. So it's therefore impossible for me to get on someone of any calibre or credibility, which you have seen the quality of people I've had on already. I'm going to have lots more people on as well. I've interviewed lots of people that you don't know about yet. I've got someone, I've already conducted this interview. I'm going to be releasing it next week. This will be a really exciting one. I can't wait for people to see this because I didn't know I was going to be able to get this person, and then I was fortunately connected with them. So that'll be really interesting. It's not Dewi, by the way, which is a slight disappointment, but I still think you'll really, really enjoy it. So yeah, I would interview someone who believes that Lucy Letby is guilty if you can show me someone with credibility, if you can show me someone with any qualifications in any even remotely related field, then I'll happily interview that person. I'm obviously not just going to interview some random person from the internet who's just spouting off because, they're perfectly entitled to their view, of course, but I only have credible people on for interviews. So all the people I'm going to have on are going to be scientists, medics. I may have some miscarriage of justice victims on at some point. There's a few that I know. And I suppose the one area where you could have someone is you could have you could have one of these legal types whose view is essentially, I think the court is great, the court must be right, the jury's, very much in the Liz Hull bracket, you might say. I just don't really see the point in having a barrister on, or not that there are an enormous number that have said that this is a thoroughly safe conviction, but you do see a few. But I mean, that's really due to their blind faith in the legal profession, their blind faith in the court system, and it's due to an unwillingness to nibble at the hand that feeds them. So I'm a bit reluctant to do that, because essentially it's usually people that don't really understand the case, don't know much about the case, and they just automatically assume that a court is correct. So I don't think it gives a lot of value for me to ask them on and say, right, why do you think Lucy Letby is guilty? Well, the jury sat in court for 10 months, blah-de-blah-de-blah, like they always say. And then I can say, well, I've got a list of medical questions for you. Would you like to try and answer them? They obviously can't answer them. For me, it's just pointless. It would have to be someone really that had qualifications, credentials, or experience specifically related to the specialisms and the areas that were relevant to the case. That person doesn't exist as far as I'm aware. Would Lucy Letby have chosen a barrister? So, as far as I understand it, this is just a court-appointed barrister. It's asking a lot for Lucy to choose her barrister when she's in prison. She's incarcerated for 2 years prior to the court case commencing. So, a barrister is largely court-appointed. She may be able to rubber stamp this to some extent, but asking her to choose it as if she goes out and searches for that person, absolutely not. I think she entrusted, as far as I understand it, there's been a lot of rumours about this, and it's hard to substantiate what is true and what is not true. I've heard some things that I know to be solidly true about this, but she may have chosen the solicitor. It's possible she chose a solicitor. I can't honestly corroborate that definitely. I've heard a lot of murmurings about it, but I can't say definitively that she chose a solicitor. She certainly did not choose a barrister. Barrister's court-appointed. Who could have stopped the juggernaut? So this whole thing could have been stopped in 4 different ways. So the first thing is the hospital and the consultants could have behaved. I mean, I believe the executives, in terms of the allegations, did behave professionally, but I suppose the hospital could have refused to go to the police. They could have said, look, you haven't provided any evidence. There's no legitimate reason to go to the police. You're the ones that are in the wrong. We're not going to the police. If you want to take it further as a whistleblowing thing, and if you want to go to a healthcare body, or if you want to go to the police on your own, let that be on your own head. But we're not going. That's one thing that could have happened, I suppose. Whether or not that's reasonable, I don't know. One of the things is that I forget which one of the consultants it was, but one of them said, "Oh, we're all looking elsewhere for other jobs, so it's up to you what you do next." So they played every card that they had in their hand, and eventually they forced the hospital to go to the police. Then, as we know, the consultants turned up for a meeting with the police and seeded them with information of varying degrees of accuracy. As I always describe it, much of it inaccurate. So I'm going to be going over that timeline of the police soon, probably in my next video after this. So that's the first, but the consultants obviously could have behaved more professionally as well, and they could have accepted, look, there's big problems with the hospital, there's big problems with the way we're dealing with these babies that have complex problems, we're dealing with an acuity that we've never dealt with before. So they could have, in that respect, behaved more professionally and engaged in more self-reflection. That's the first thing. The second thing is that when it was handed to the police could have done their due diligence in numerous ways. I don't know if I can list all the ways that the police could have done their due diligence but didn't. But a couple of ways would include they could have done their due diligence on the consultants. They could have found out the consultants had been criticised by the hospital in an independent grievance procedure and that they had a clear vested interest. That never seemed to enter into the police's thinking at all. In fact, it clearly didn't enter in the police's thinking. And obviously they could have done the due diligence on Dr. Evans. That's obviously the third area. Someone competent could have walked into the police station. So if it was any neonatologist, and I would suggest any paediatrician, basically in the world, other than Dr. Evans, then I don't think it would have gone any further. I think they would have conducted what would have been a more thorough review and come to similar conclusions to the expert panel. And then the fourth thing is, in my view, we're going to come on to the Crown Prosecution Service in a second, but in my estimation, the Crown Prosecution Service is not fit for purpose. They have no ability to assess these cases. If they were a competent organisation with qualified and credentialed people, they might have been able to see that the evidence presented was very weak and that this was a huge potential for an unsafe conviction, which of course it obviously is. So there was 4 ways that this juggernaut could have been stopped. Unfortunately, none of those things happened. So I'm going to read this comment out that someone has left, and at the end of that I'm going to respond to what they say at the start. So, you mentioned the CPS but seem to dismiss this. In fact, the role of the CPS is supposed to be one of ensuring only well-founded cases on reliable evidence go to trial. They are supposed to push back on fanciful police frolics and recognise the flaws. The CPS was only established in the 1980s. Before then, the police prosecuted cases. It was because of the run of miscarriages of justice culminating in the Birmingham Six that an entirely separate organisation was established, designed to be a check and balance on injustice. But working relationships became closer over time, with CPS reps embedded in the police for ongoing consultation. Keir Starmer embedded the dubious concept of case building on presumption into the CPS when he was Director of Public Prosecution. So instead of pushing back, they often simply helped push forward in a joint enterprise. During the trial preparation, solicitors' correspondence with the defence solicitors, and that is where much of the battle lies. Pressing for information and unused evidence, etc. The unused is a whole other can of worms. I mentioned an aspect of this to you on YouTube, re the Ravi Jairam email on the Baby K case, and the claim on Panorama had been disclosed at trial. As I implied, barristers are often simply the creative actors in the case. They have to juggle with the dynamics of the courtroom, judge and jury. The material should be provided by the solicitors, who get most from the CPS, who get theirs from the police, other than defence witnesses. Another case flaw, particularly the absence of good character witnesses for Lucy Letby. I hope if and when this case is overturned in the Court of Appeal, a proper public inquiry is held to look at the criminal justice system and the role of the police and Crown Prosecution Service in terms of systemic flaws. In this case, it began with accusations of crimes against a suspect which became presumptions. Nowhere is this more apparent than the desperate attempts to pin Lucy Letby to the insulin cases, despite the inherent improbability, if not near impossibility, of her being able to contaminate the bags. Not once, but twice. The insulin cases wouldn't have been a thing, but that they held up the creaking joints of the other cases. So let me just respond to this bit first. I agree entirely that there needs to be a proper inquiry into the role, the way the criminal justice system is run, the role of the police, the way the police investigate cases, and the Crown Prosecution Service in terms of systemic flaws. In fact, I've said before, and I'll say again, that unfortunately Lucy is the sacrificial lamb in this, and that's really enormously sad on a human level. But this is something that needed to happen. We've got a woman in Birmingham now who has she's been being investigated for over 3 years now. There was an update on this very recently. So she's still under investigation now. This is due to one death of one baby in a hospital that is suspected to be due to poisoning. Now, that should, to be generous, let me be extremely generous, that should take 2 months to deal with. You know, you have the infant, it was on the day that it occurred, that she was reported to the police, as far as I understand it. So, the infant, it's not like the Lucy Letby case where they're looking back years after this has occurred. So you do some tests very, very quickly, get the test back, and then find out whether it's a poisoning, and then that's it. So that should take, as I say, to be generous, 2 months. And over 3 years later, she's neither been charged nor cleared. So that suggests to me that they're looking at every single case in Birmingham that they possibly can, and who knows where else, and who knows what they're doing, and investigating everything. And they're using the template of Operation Hummingbird, and Birmingham police are thinking, wow, loads of funding, isn't this great? That's just my speculation, I don't know that, but I can't see any other conceivable reason why the investigation of one infant for poisoning takes 3.5 years, and it's still under investigation. So let me be clear that in David Conn's article for The Guardian, he stated that it is expected that the Thirlwall inquiry will make recommendations that cases are referred to the police more quickly if there is a spike in deaths. This isn't even a spike in deaths. This is one death that presumably the hospital decided, right, we weren't expecting that, so we'll just report this. And then the police are investigating it 3.5 years later. that has to be considered very worrying, and that has to be considered particularly worrying for anyone that works in the nursing profession. So if Thirlwall start making enshrined recommendations and they are turned into law somehow, which is possible, I don't know exactly what the limitations of the Thirlwall inquiry are, but if they make these recommendations and they are in any way enshrined into law, that's extremely dangerous for every nurse in this country, undoubtedly, unquestionably, because those recommendations haven't even been made yet, and already, when there was this one slightly unexpected death, the first instinct of the Birmingham hospital was to go to the police. Now, I presume they don't have really strong concrete evidence, because if they did, they would presumably already have charged her. Although maybe they do have strong evidence, and they're now just looking at every single case in Birmingham over the last... Who knows what they're doing? Like, we've seen how incompetent Cheshire Police are. I have no reason to believe that the Birmingham constabulary, however you describe that particular constabulary, I don't know their official name, I have no reason to believe they will be any better. So I'm in complete agreement with the last paragraph of this letter, and unfortunately this is something that needs to be resolved. It's not something that can be swept under the carpet. Yes, I think Lucy should have gone for constructive dismissal. If she'd done that, she probably wouldn't be in the situation she's in now, but it would have happened with someone else. Absolute certainty. And until this is properly resolved, until, we teach the police how to investigate something, and there's very deep systemic problems in the police in this country, that's very clear. That's crystal clear from this case, and now it looks to be very clear from what's happening in Birmingham. So until the police are actually educated on how to investigate, because it's very clear they didn't know how to investigate this, then this will happen again, and it'll happen again and again and again, in fact. So that's just not an option. So for me, once Lucy is exonerated, definitely, I already have a small voice in this, I suppose. As my voice grows, which seems likely to happen, then I will use it. I will never leave behind this field. I'll be working in miscarriage of justice for the rest of my life in some capacity. I want to write more books, and I will use my voice as I can and the connections that I've made as I can. Because this can't be swept. We can't at the end of this say, oh well, that's a bit of a shame that Lucy lost 12 years out of her life, what a blow, never mind, let's just carry on the way we are, this system works perfectly well. We're looking at an antiquated system that can't deal with these cases, can't deal with scientific evidence, let alone can the police deal with it. The police just haven't got a clue, frankly. They might as well be like prodding around in the dark with a stick for all the use they are, frankly. So yeah, I wanted to respond to that point first. And then this other thing about, you mentioned the CPS but seemed to dismiss this. I didn't mean to be dismissive of the role of the CPS. What I was dismissed, and I was aware of what's mentioned in this post, but what I was being dismissive of in these comments that you're probably referencing is the ability of the CPS to do its job properly. Because the CPS is a two-stage process. Stage 2 is to decide whether or not something is in the public interest as a prosecution. So in this case, that's out the window immediately. Of course this is in the public interest if Lucy's guilty. Of course it is. So that's one stage of the process immediately eliminated. So then you're down to the other one, which is they have some sort of template to decide, I would assume, to decide whether or not there's enough evidence for it to go to court. Because they don't have scientific expertise. They don't have any qualifications or credentials in the specialisms required. So I would suggest to you that what they look at is the quantity of evidence primarily. They will make some effort to look at the qualitative evidence, but in this case, it all looks fine. It looks, oh look, we've got a paediatrician in, we've got a doctor in, he said it's definitely 100% solid, we've got this, we've got that, we've got a statistical case, or you've decided to cancel that obviously, so we don't need to bother with that. Obviously I'd also be critical of the CPS cancelling the work of Professor Jane Hutton, clearly. I mean, that seems utterly unjustified, and the only possible reason for it seems to be that it would have made a conviction more difficult. Now, that's not a valid reason. The role of the police is to establish the truth, and the role of the criminal justice system is to establish the truth. It is not to prosecute people. That is not the purpose of the criminal justice system. Yes, it is to prosecute people who are guilty, but it's also to protect people who are innocent from being wrongly prosecuted. So I'm not critical or dismissing or diminishing the role of the CPS. I'm critical of whether they have the capabilities to perform that very important role, which I'm very doubtful of, frankly. Chris, may I ask if Thirlwall is paused or concluded? So it's certainly not concluded, but I said in a previous video that it was paused. that's not strictly accurate either. What I meant was that it had been the point where Lady Thirlwall is going to announce her recommendations has been pushed back to January. So effectively that is kind of a pause, but it's not an indefinite pause because it was supposed to happen in September, so it would have already happened, of course, because we're in October now. So she already would have announced her recommendations. It's now due to happen in January. And as I said during Mark's live stream that I mentioned, I have absolutely no idea what's going to happen. I literally have no idea. I couldn't even make a guess. I know what should happen objectively. Objectively, it should be pushed further back or paused indefinitely. Whether that's going to happen or not, I don't know. Lady Thirlwall is very difficult to predict what she's going to do because she made some comments at the beginning of the Thirlwall inquiry that I think were very unwise indeed. She has pedalled back from that a little bit, and comments she made towards the end were far more credible, I would say. But even so, she still decided at that time, I'm not going to pause, we're going to continue, we're going to do the recommendations. So I really have no idea what she's going to do. Objectively, she should stop the inquiry and say, look, we can't possibly continue and make recommendations based on this farce of an inquiry in the current climate, but who knows what she'll do. Hi Chris, please could you let me know, is it possible to write or email Lucy? It is possible. It's somewhat difficult because if you write to the prison, I'm fairly reliably informed that she's not receiving things for one reason or another. You can write to her via Mark MacDonald. Mark MacDonald's chambers are available online. I know that he's received an enormous amount of correspondence and he's going to make sure she receives it all. But that's going to be when she comes out of prison. So in terms of having immediate contact with her, it's very difficult. I haven't written to her personally. I've not had any contact with her. In terms of an email, as far as I understand it, prisoners are not given email access and they're not given internet access. I know they're given laptops and TVs and stuff like that, but I think it's without the internet. So I wouldn't think it's very easy to write to her at this point in time, but by all means send her a letter via Mark MacDonald and she will receive it eventually. So the same question is the same. Is Lucy allowed to receive mail? She is allowed, but it's very difficult to get that to her. So another question here is another idea. Would it be possible to email you and perhaps you could pass my message on to Lucy's parents? So I haven't personally written to Lucy's parents. I wouldn't like you to do that at this point in time because I'm not 100% certain I can get their address, although I think I can. I haven't had any contact with them. I do intend to write to them at some point. And I guess if I establish a relationship with them, then I don't mind passing on messages to them. It's just a case of really whether or not that's going to be helpful for them or not, which is hard for me to say. They're obviously in an incredibly difficult position. They're serving the sentence with Lucy. They're living in prison, essentially. I mean, how could they possibly derive any joy from the little things in life and the kind of pleasures? I mean, they must be, if they're in anything other than a state of depression, then I can't imagine what their lives are like. It's just awful. For anyone that's wrongly convicted, it must be an absolute nightmare for the parents. My heart goes out to them. So I do intend to write to them at some point. If I do so and it's kind of successful, then I might indicate that on here and then maybe people could email me then. I don't think we should do that at this point in time because I would rather kind of establish at least a contact with them first. So I will kind of keep people updated on that as and when it happens. For the time period, is it known how many Datix reports were made, who made them, and what level of expertise, e.g. qualification, band? I can't believe Lucy was the only one. Are there any Datix reports submitted by medical staff? Did they feel they were being criticised and therefore exempt? Who were Datix reports submitted to? Who analysed them and fed that information to whom? This has always amazed me. I never thought such a thing could happen. Is this not something that the CPS should have disallowed or that Judge Goss should have found inadmissible? So I assume that's referencing the Datix information, the last question. So I'll go through those questions individually. For people that don't know, the Datix is kind of a internal hospital information system. It's not known how many Datix reports were made in total because this is classified information from the hospital. They've been made available by the Thirlwall inquiry to a certain extent, but Thirlwall is not exactly completist in its attitude to releasing documents, so we can't really say with any confidence that we've seen all the Datix reports. In fact, we can say quite confidently we haven't. So it's impossible to say how many. Various people will make them, various levels of expertise, qualification and bands. It's not just limited to Lucy. What I do know from having a neonatal nurse examine the Datix reports that are available is that she said Lucy was the most diligent chronicler of information on that ward. This is what Karen Rees has said. Karen Rees says she's an outstanding Datix compiler. She'll write Datix information against herself, the implication being that other people won't do that, which is kind of understandable, I suppose. But Lucy was committed to doing things by the book, according to the rules, to the best standard possible, and you're supposed to fill in Datix. As we know, and this has been discussed on the channel previously, consultants aren't always keen on nurses filling in Datix. It seems very odd that this is allowed to happen, but apparently it is allowed to happen, so they don't always get filled in, but Lucy was very diligent about that. But she won't be the only one. Lucy won't be the only one filling them in. There will be other people Datexing various information, and there are records in Thirlwall of other people doing this. So the question, did they feel they were being criticised and therefore exempt? So the kind of controversy about Datix is that it seems that hospitals, and obviously I'm speaking here about something that I don't have experience of directly, but I'm relaying what I've heard from people that have a lot of experience. Hospitals are hierarchical. I mean, that's very clear from the way that they're run, the various salaries people get, and so on. But that is reflected in the day-to-day running of many hospitals and many NHS trusts. So I think the issue generally is that consultants, certainly I've been told consultants essentially run the hospital. But we've seen that quite strongly in this case, where the consultants ultimately got what they wanted from the administrators. The administrators and the executives could have, as I just suggested, could have said, look, we're not going to the police, you can go to the police, you can do whistleblowing, we're not doing it because you've got no evidence. And frankly, you've just been found out by a grievance procedure, you should be showing some contrition and humility at this point. Of course, they didn't say that because the consultants are really the powerful ones, and they know that. So, I mean, I've broadly heard, and obviously there are loads of wonderful consultants out there, that's not in doubt, but there are a certain number that seems to be very egotistical from what I've heard, and they don't take kindly to a nurse pulling them up on stuff. And that is really the problem on the unit, is that you have nurses, particularly Lucy, it seems, writing critical remarks, or not what she would have seen as critical remarks. She would have seen them as honest remarks attempting to improve practice. But given that there were so many areas in which they could have improved practice, there may have been a lot of Datix information from her, and it might be, oh God, not Lucy Letby moaning on Datix again. Now, I don't necessarily believe that was the reason she targeted. It can be a contributory factor. I don't know. It could be that previous healthcare serial killer convictions, whether safe or otherwise, were in the mind of Stephen Brearey in particular, and that's why he was willing to cite Lucy as being suspicious so quickly. That can be a factor. It's a kind of self-serving opinion. It can just be because they made a mistake intellectually and they jumped to conclusions that are incorrect and they couldn't see their own kind of confirmation bias and so on. It can be a variety of factors. I don't have a good reason as to why Lucy was targeted, or, as I say, I've said previously, I don't think she was necessarily deliberately targeted at the start. But the Datix can be a factor in that. I think that's a reasonable comment. Datix reports aren't submitted as such. They are, there's like a system, a central system, and they just, within the hospital, and they just write them onto the system, and they're there, anyone can access them, presumably on the system. Who analysed them and fed that information to whom? I really don't know can't give you a very good answer to this. I'd have to ask someone who knows more about nursing and the way hospitals work as to who. I mean, theoretically, it's not that the information gets fed to anyone. The information is there on a system, and practices are highlighted, and mistakes and little issues within the hospital, and then people that work on the unit are supposed to look at them. Now, what the procedure is for when they look at them and how they look at them, I assume managers like Karen Rees, for example, and Ariane Powell, it's their job to flag these things up and just say to the nurses, look, you're not doing this correctly, or this isn't being done correctly, and the same for the consultants. How that actually works in reality, I don't know, but I would assume managers survey the Datix system and then make communications and convey things to their staff as is required. And then finally, is this not something the CPS should have disallowed or that Judge Goss should have found inadmissible? I think to use Datix information is legitimate, perhaps. What is really strange is that in this court case there are several examples, and I'm going to do a video of this in the future. It's just this one takes a while to put together. I will go through it and I will do it. But there are several accusations that are made by the prosecution that Lucy Letby changed Datix information or fabricated things or falsified records. That is all completely fabricated. There is no evidence for that. It's just a pure invention of the prosecution with no supporting evidence whatsoever. And it's not even that difficult to demonstrate this. It just takes time because you have to go through the entire court case. So I will do that and I will demonstrate that eventually. But in my view, that I don't know what is or isn't admissible evidence, but it seems to me the prosecution is just allowed to go crazy and say, oh yeah, we say you did this, we say you did that. There's no evidential support for that. They just say that that's the case. I mentioned there was a court case recently in which someone was convicted of spying for Russia, and they were allowed to get his ex-girlfriend in the witness box, and she said, oh, he was obsessed with James Bond films. Absolute crap, obviously, but that was allowed in court. So I don't know what is not admissible. It seems that almost anything is admissible. Did the police investigate the other 6 deaths in the cluster, and if not, why? Yes, they did. The police investigated 17 of the 18 deaths that were associated with the Countess of Chester in this period. For some reason, they didn't investigate one of the deaths that occurred on the Central Labour Suite. I have no idea why. I couldn't give you a good reason for that, but they did investigate the other deaths, yes. By the way, would you like to be a journalist, investigator, investigative reporter, or a lawyer one day, or to analyse other topics down the track, write other books? So I will be writing other books on miscarriages of justice, almost certainly. I've already got an idea. Well, that's actually not on miscarriages of justice in the same way that we would understand it here, but it's another legal criminal justice related idea. I'm going to write more books about Lucy's case. I have an idea for at least one more, and then perhaps a third as well. I'll definitely be writing other books on other subjects as well eventually. We'll just have to see how things work out. I mean, before I started doing this, I was a ghostwriter, as many people may know, and I'd written and edited 50 books, and I just used to churn them out. I spent the last several years just doing very little other than writing books. I'd have a bit of downtime. I'd go on holiday occasionally, travel a little bit, have a few days off, socialise, the odd day off here and there to see friends. Obviously take my dog out, Kiko, whenever I can. I like to do a bit of cooking, play a bit of chess, but a lot of my life was writing, and now that's why I found it easy to do this and to just pivot into doing this and work very hard on this, because I'm a hard worker and I'm not scared of hard work, and if I'm passionate about something, I'll just do it and do it and do it until it's done. So I knew that I had that experience a couple of years ago when I started to research, and I just felt that this was something I needed to do. And then when the opportunity came, I knew the time was right to write a book. I thought, I have the opportunity to do this, I have the expertise and the experience, so I should do it, because there may be no one else out there that can do it. There may be people that would love to do it but don't have the time. There may be people who love to do it that don't have the experience or the expertise or the confidence. So I knew that I could do it, so I thought I should. Obviously, I didn't plan to do YouTube. That's just been a very rewarding and unexpected part of my life now. But yeah, I'll definitely be writing other books. And I think after Lucy's exonerated, I will definitely keep this channel going, because I'd hate to lose touch with everyone. And there's so many other interesting topics that we can cover, and people seem to enjoy my podcasts, if you want to call them podcasts, or video essays, or however you want to describe them. So I definitely want to keep going and do more stuff, and maybe I can do a bit of, analysing cases where people were guilty. I mean, I still have a video that I've been planning to do for months and months and months, showing the kind of writings that people who were serial killers do, which I think will be really illustrative and interesting. I just haven't got around to doing it because something new happens in this case every week, and then I shelve all the videos I was planning to do. So yeah, I definitely would like to analyse other topics. I guess I kind of am a journalist a bit. I've done journalistic work and I have the skills to do that. I'm not like a pure journalist like Anouk is or like Clancy is, but I would like to think I have journalistic qualities. And I do like doing investigative reporting, and I did see a job for I think it's Bellingcat they're called, who do some very brilliant investigative reporting, and I'd love to do something like that. I wouldn't want to be like a journalist sitting in an office doing stories all day. I can do that, but it's not that interesting for me. I like to do investigation and deep dives and lots of research and longer form stuff. That's why I like writing books, of course. So I don't really want to be a journalist in the sense of sitting in a news office. And obviously, once you get used to, like I haven't had a job for 15 years, and once you get used to it, very difficult to me imagine myself having a workplace and commuting, etc. In terms of being a lawyer, I think I'd have some qualities that would be quite good, but I would find it very difficult to defend someone that I knew to be guilty or to prosecute someone that I believe to be innocent. I guess a human rights lawyer or something like that would be good, but I mean, I'm too old. I'd have to go and do the bar exams, and I don't want to. I know how boring it is to study law, so I think that's one of the reasons it's well paid. It's not the main reason, but if you want to get to be a qualified barrister or lawyer, you've got to get through the exams. I don't know what it's like in other countries, but in this country, I know it's very difficult, very demanding. It's a very dry subject indeed. So I love writing. Writing is what I love doing. I love doing creative things. Obviously, I do YouTube, but I really don't consider myself to be a YouTuber. I mean, I'm leaning very heavily on my writing skills here, and also on my research skills that are very strongly related to writing. So yeah, I hope that answers that question. Will anyone be prosecuted? So this question reminds me of the film, what's it called? National Treasure, that's got Nicolas Cage in it. So that is a rubbish film, but I must say it's quite entertaining. I enjoyed it when I watched it. I mean, I was rolling my eyes at virtually every scene because it was absolutely ludicrous, but it was entertaining. But anyway, basically what happens in National Treasure is that it's either the Bill of Rights or the Constitution of the United States is stolen. And then right at the end, the guy who's stolen it, which is played by Nicolas Cage's character, gets accosted by the police. It's a bit like Catch Me If You Can with Tom Hanks and Leonardo DiCaprio, in a way, in that it's someone pursuing someone else. So what's the other one with The Fugitive with Tommy Lee Jones and Harrison Ford? So right at the end, I think they're like in a church or something, and they're sitting down and they're talking about something, I can't remember, and Nicolas Cage's character makes some comment about prison, and the guy who's speaking to me from the police says, look, the Bill of Rights has been stolen, someone is going to go to prison. And that's basically the situation here. You can't have something of this magnitude. When Lucy Letby is exonerated, which is inevitable, there's going to be some serious shit hitting the fan in a serious way. So the idea that everyone's going, oh, well, hey, we all made a horrible mistake. What a shame. Someone's going to get prosecuted and someone's going to face serious consequences. That's a certainty. There's going to be a series of inquiries and everyone's going to have to face the music. Now, the police usually manage to weasel their way out of everything. Dr. Evans is very vulnerable. The consultants are a little bit vulnerable. The hospital will probably be okay because it's a hospital, and this is one that let me just on an aside, let me just mention this because I've not fitted this into a video yet, and this is really important. So one of the ways to think about a hospital is that as a local business, if you take away the corporations and take away the banks, which are multinational, In terms of being a local business, in most towns in the country, the hospital is the biggest business. It's the entity that's worth the most money. I don't know how much it would cost to build a hospital, but a fully fledged NHS hospital with all the departments, all the specialisms and everything they deal with, it must be 100 million. I don't know how much it would be, but it'd be an enormous amount of money. So most football clubs would be the second highest. If you're in a major city like Manchester, Liverpool, Birmingham, London, then there are football clubs that are worth more than a hospital. But in most towns in the country, the hospital will be the biggest local business. So in a way, it's the most powerful entity outside of the corporations and banks in most towns in the country. So that's why they can do what they've done, which is put a shield up around themselves so that no one can penetrate it. So the hospital is a very powerful institution within Chester, and I don't think the hospital will face serious consequences, but some of the individuals could. Do you think some of the main actors in this case are watching your channel? So that's a really good question. I can honestly say before you asked me this question, it had not occurred to me. I'm always surprised when I encounter people, I had no idea, Professor Colin Mulley's watching my channel, for example. I mean, that's really flattering, and it seems so many people are watching it. I can't really believe it, but I guess there's a distinct possibility that they are. On the other hand, it's part of human nature to just put our heads in the sand and brush things under the carpet, so it's possible that the main actors are all just... I mean, I don't think Dowie would be, because Dowie lives in his own bubble. And he's not a modern person. He's obviously quite an elderly gentleman. He's not really internet savvy, so I doubt that he is. But I think possibly Brearey, particularly J-Ram, could be. They seem a lot... J-Ram in particular seems a lot more modern, and he could be engaging in self-reflection, and he may have seen something, I don't know. But it's very hard for me to say, of course. Will the presence of pseudomonas on the unit be submitted to the CCRC as it was concealed by the hospital? I can't say for certain whether it will be or not, but it would be surprising to me if it wasn't part of the CCRC submission, considering that it plays a significant role in sepsis, and sepsis is cited in several of these cases by the panel. So I think it's likely that it will be, but I don't know for sure whether or not it is. If the Court of Appeal decides to retry some or all cases, are the prosecution obliged to play, or can they wave the white flag? So in order to answer this question, we're going to go to our good friend ChatGPT. I do have a good idea of the answer to this question, but we're going to investigate this in more depth. Okay, so there's a few things to go over here. If the Court of Appeal orders a retrial in a case that produced a conviction, can the Court of Appeal decide to retry only some of the convictions? Yes. So this is why I've suggested that they may seek a retrial on the insulin cases and child O as an example, and throw Dowie out the case completely. Under Section 7 of the Criminal Appeals Act 1968, if the Court of Appeal allows an appeal against conviction, it may order a retrial if it considers it in the interest of justice. The Act doesn't require the retrial to cover all counts or convictions from the original trial. The court has discretion to limit the retrial to specific charges. So then he asked me, could you show me a real case example where this occurred? So R versus Maxwell, 2010, Paul Maxwell and his brother Daniel Mansell were convicted of 1 count of murder and 2 counts of robbery. The key witness was a supergrass whose testimony was central to the prosecution case. Later investigations revealed there had been non-disclosure by the police of benefits and other incentives given to Chapman, plus associated misconduct. More great work from the police. And then it goes on. Although Maxwell's conviction, all 3 counts were quashed, the retrial was only ordered for some of the counts, specifically those for which there was new and compelling evidence untainted by the misconduct. For Mansell, there was no new or compelling evidence beyond the tainted witness evidence, so the retrial was not ordered for him. Incredibly, Maxwell eventually pled guilty in the retrial to certain counts. So something I'll just mention briefly at this point is that the prosecution can, the Crown Prosecution Service, I don't know exactly the mechanism how this works, but the prosecution can use a completely different case next time. So they could just pick out one case as an example. So let's say they went for child O. Let's say they threw everything else out and went for child O. Not only could they just focus on that one infant alone, but they could also completely change the allegations. So they could say, right, well, we don't think this infant was actually injured by the tool down the esophagus allegation that Dewi Evans has put in the case. We think it's now this. Now, obviously, that's not very likely because it would make the prosecution look ridiculous. But they are allowed to do that. They are allowed to completely change the case, get completely different witnesses, do new reports, and just the prosecution case could be materially completely different from the original trial of Lucy Letby. The likelihood of that happening is slim, but it can happen. So then I've asked, are the prosecution obliged to prosecute in a retrial when ordered by the Court of Appeal, or can they wave the white flag? So under Section 7, when the Court of Appeal allows an appeal and quashes a conviction, it may order a retrial if it appears to the court the interest of justice so require. This means the court is saying, in effect, this conviction is unsafe, but there is evidence on which a jury could properly convict, so the matter should be tried again. However, the retrial does not compel the prosecution to prosecute. The Director of Public Prosecutions or Crown Prosecution Service is responsible for deciding whether to continue. This means they must be satisfied there is a realistic prospect of conviction and the prosecution is in the public interest. If those tests are not met, the CPS may decide not to proceed, effectively waving the white flag. So as an illustrative example here, R versus Mullen. The Court of Appeal quashed Mullen's conviction on abuse of process grounds. It did not order a retrial, but the judgment made clear that even if it had, the CPS would retain discretion whether to prosecute again. So then I've asked for an example here. Robert and Lee Firkins, Cornwall double murder. Robert and Lee Firkins were convicted of the murders of Carol and Graham Fisher. Convictions were quashed by the Court of Appeal on the basis that the convictions were unsafe. After the appeal, the CPS applied for a retrial, which shows they were at one point intending to re-prosecute. However, before a retrial could proceed, the CPS offered no evidence in the court, meaning they effectively discontinued any further prosecution. A specific issue cited was difficulties around witness attendance. One or more witnesses would not be able to attend. So what circumstances under which they would do that? That honestly is open to pure speculation. It's such a prominent case, they probably wouldn't back down. That would be an enormous embarrassment for them. Who knows what's going to happen in this crazy case, but they can. They can wave the white flag, as you put it, if they wish to do so. I have read that while Lucy was on a holiday in Ibiza 2 weeks, the deaths and collapse on the neonatal ward paused, implying that they continued after she got back. I find this difficult to believe. What is the evidence for this assertion? If true, is there an explanation? So, essentially, this is complete crap. Obviously, if the deaths stop for 2 weeks and then start again, that is just an example of utter confirmation bias. It's utterly meaningless. It has no credibility whatsoever. It really cannot be taken seriously. The explanation is that they were obsessed with Lucy Letby and they found evidence and they managed to fit it around the assumption that Lucy is guilty, and this is evidence that has absolutely no merit whatsoever. I know that when Lucy was redeployed away from the ward, the death rate decreased. This was because the hospital was downgraded and dangerously ill babies were sent elsewhere, but was that explanation concealed from the jury? Of course, being under scrutiny would have improved the level of care and also contributed to a better overall outcome. I wonder if the jury was made aware of that. So, as Liz Hull likes to remind me, I wasn't in court and I didn't see the whole trial. We obviously have this ridiculous situation where we have to beg, borrow and steal to get as much of the transcript as we can. It's absolutely farcical. It's another major embarrassment for this country that court proceedings aren't more transparent as they are, for example, in the United States. This court case should be transcribed very clearly, it should be readily available, and indeed it should be recorded. We imagine how much it would have been poured over by now if we could easily get hold of the whole transcript, which should be the case. With that being said, from what I've seen, which is all the court reporting, quite a lot of the transcript, things that other people have covered, things that I've been able to get hold of, I've seen a lot of the court case now. I accept it's not all of the court case, and I have not seen any reference to the hospital being downgraded anywhere. There may be one that I haven't seen, but I haven't seen one anywhere. And we know for a fact that Dr. Stephen Brearey gave the impression that the unit was improving. So, in my view, the jury were given a completely unrealistic impression of what was occurring on the unit. Also, they weren't allowed to see the RCPCH report. The judge ruled that to be inadmissible and irrelevant. So, I don't know if you could say it was concealed from the jury, but it wasn't communicated or conveyed to the jury, as far as I can tell. The defence team seemed to have been strangely ineffectual. I wonder if they felt there was no case to answer. Did Lucy's colleagues also fail to give effective support because they thought her innocence was obvious and she would be exonerated without any special effort on their part? So the defence team certainly should not treat this as no case to answer because it's in a Crown court and she's facing very serious allegations, so they should not be ineffectual, as you put it. I think Ben Myers has done some good stuff. I think the defence team has done some bad stuff and there are some omissions. There were things that I would definitely have done differently. However, some of the problems are to do with problems with the legal system, problems with the system that operates in this country, and problems with witnesses more broadly, but I agree that they could have done better. In terms of Lucy's colleagues, they were warned not to give evidence in her favour. People wanted to give witness evidence in her favour and they were told it'll ruin your career if you do this, which I think is despicable, but it happened. We know this for a fact because there have been whistleblowers. So that would perhaps indicate why Lucy's colleagues failed to give effective support. I'm really curious as to how the members of the actual jury feel now. I know juror identities are confidential, but are they allowed themselves to choose to break that on their own behalf? I wonder what they would say now. So again, we'll go over this in detail. Let me deal with how the members of the jury feel now. I am certain that some of them will have very serious concerns about whether or not this is a safe conviction. They must do, because they will have heard about it. They're hardly going to live under a rock, or they can't be so concealed from reality that they don't know what's going on with Lucy Letby, and they don't know what's going on with people challenging the conviction, etc., etc. They can't be. So if that is the case, they must be looking at what's been produced, and they must be thinking, wow, I wish we'd seen this at the time, and this could be an unsafe conviction. As to the jury identities being confidential and being allowed to break that, I will go over this now. So the regulations around the jury are quite specific. There's some degree of secrecy required regarding the jury under the Contempt of Court Act 1981. So you can't disclose what was said, how people voted, how decisions were reached during deliberations. If there is evidence of corrupt or external interference, you're allowed to mention this. There are safe and lawful reporting routes that you're allowed to follow. It says here, jurors must not discuss the case publicly, reveal how others voted, coordinate as a jury group to issue a statement. And then I asked, in the Colin Norris case, jurors came forward with concerns and spoke with the BBC while Norris was still in prison. Can you explain how this is possible? So there's two jury members came forward. That didn't prevent the Court of Appeal from turning away the conviction due to terrible mistakes made by the defence. But anyway, that's another story. So the trial is over, the verdict's been delivered. So jurors are no longer bound at this point in the same way as during the trial, deliberation and process. The duty of secrecy applies to what happened inside the jury room, but some things can be addressed after. The contempt of court prevents disclosing statements made, opinions expressed, arguments advanced, or votes cast by jurors during deliberations. What the jurors in Norris's case did was to express a change of view on the verdict based on new evidence that was external to the deliberations. They were not reporting on how they deliberated, nor what exactly each juror said. So there's precedent and legal interpretation that allows them to do this. So in Lucy's case, someone could go to the media and say, you know what, I've seen all this new evidence and it looks pretty shaky to me now. Whether that will actually happen or whether they would take the risk required to do that is another matter entirely. But we can hope that occurs. I'm just going to go to this question now at the top because this is the next question on the list. Can the jury in a UK court case protest to the court that they gave a verdict based on what has now been shown to be corrupt or incorrect information and they therefore wish to retract their verdict? And the answer is no. A jury cannot formally retract or change its verdict once it's been delivered and recorded in court. However, if it later emerges that the verdict was based on corrupt, false or misleading information, there are legal mechanisms by which the case can be reopened or reviewed, just not through the jury itself. So of course that is happening now, but the jury can't say, you know what, that was a pig's ear of a court case, we retract our verdict. That just can't happen. Does an independent expert witness have to sign a form stating they know of no one in the case they are offering their services to before they start work? So there will certainly be disclosure forms that independent witnesses have to sign, and they're not allowed to know people in the case, but they are allowed to know other witnesses because there's only a limited number of them working. So they couldn't know the defendant, or they couldn't have a personal relationship with the prosecution. But the rules are interesting because obviously Dewey's worked with the police, so he had personal relationships with the police, but I guess the police are not in the court case as such, so that was deemed acceptable. May I ask a general question? In Dr. J. Ram's email of 2017, he clearly states that he was called to the unit by Nurse Letby. In that same email, he mentioned that the breathing tube had become dislodged. Was the dislodgement recorded on the baby's notes at the time? If so, who entered the note? Did Lucy Letby confirm that the tube had become dislodged? So this is fairly simple to answer. There's no recording of this on the baby's notes at the time because J. Ram only spoke about this a very long time after it happened, over 400 days after it first occurred was when he first mentioned it to the police. In terms of Lucy confirming the tube had become dislodged, it's still debatable whether a tube actually became dislodged because it's not in the notes. So this is just based on someone's eyewitness account, very unreliable eyewitness account. It's not properly established that there was a dislodgement. Could the defence see the police station visitors log for May, June and July that ought to prove or disprove Dr. Evans' claim to have visited there in July? So I mentioned this in a recent video. I now know that Dr. Evans did first visit Cheshire Police in July, approximately on the 10th of July. So I'm going to go over that timeline in what will be my next video. So I suspected there was a possibility that he'd visited for the first time in May, but I now know that to be untrue, and I've seen documents and been made aware of documents that indicate that this is the case. You claim you're 99.9% sure Lucy Letby is innocent, but what if the test used on the two separate blood samples that showed extraordinary high levels of insulin, according to experts, just so happened to be correct? Wouldn't this mean someone would have had to have injected those babies? What if the results were in fact accurate? So let me just answer the second question first. So there's no allegation that babies were injected. The allegation is that Lucy injected insulin into feeding bags and these were hung out for babies. So that's the first thing. Let me just deal with the statement about... Let me say firstly, this is a very fair question. Let me just deal with the statement about why I'm 99.9% sure. So, Lucy, let's look at the insulin cases just as an example. So, she's not on duty when the bags are hung out. There's no evidence that the bags were spiked. It's completely hypothetical. Lucy had no knowledge of which bags would be hung out. If she'd already murdered babies with air, it doesn't even make any sense because she wasn't successful with this. Then she went back to air, then she tried another insulin poisoning, failed again, then went back to air again, which no murderer would do that when obviously air is much, much harder to detect than insulin. And she'd been successful, then she was unsuccessful with insulin, and the insulin cases are the case that got this case to court. So that in itself makes no sense. The testing obviously wasn't done properly. The follow-up testing wasn't conducted at all. We now know more about the anatomical state of neonates and how even the figures that were obtained are misleading. There's the third insulin case that basically should torpedo the whole thing automatically, but because it's Britain and this is, a failing country, essentially, it hasn't. And then on top of that, we have the fact that Lucy herself essentially proclaimed her innocence in the blue post-it note. So she didn't know anyone else was going to see that. So she would not be sitting there calmly writing, well, there's obviously no evidence against me. If she deliberately poisoned infants with insulin, she would obviously know that there could very well be evidence. She'd be shitting herself thinking, oh my God, they're going to find the insulin cases and then I'm going to be in big trouble. She'd not be writing down, oh, well, there's obviously no evidence. Anyway, I've got an occupational health meeting. I better prepare for that. I need to get back on the unit. And then on top of that, there's no change in her demeanour. There's no kind of psychological deterioration. There's no motive for her. She doesn't reference any murders at any point. No one in the unit suspected anything. No one saw anything. So if you put all these things together, just some of the things that come to mind off the top of my head, I'm 99.9% certain that she's innocent. The only reason I don't say 100% is that I don't make false claims. So some people claim that they're 100% certain that she's guilty, which is impossible. So I don't claim to be 100% certain of innocence because that's impossible for me. I just use 99.9% as a very high figure because I absolutely believe that she's innocent. All the evidence points to innocence, and I think it's almost inconceivable at this point that she's guilty. However, I can't say it's 100% because I wasn't there at the time, and it's literally impossible for me to be 100% certain. In terms of what if the results are accurate, the whole point is that they haven't measured. I mean, the whole hypothesis can be complete rubbish, and probably is, because it's not based on measurements. It's not based on direct measurements. It's based on figures that were seen in the infants. It's not if they'd got a feed bag and they'd kept a feed bag and they directly tested a feed bag and they said, wow, the insulin in this feed bag's off the chart, that would be very serious. But they didn't do that. They didn't keep the feed bags, they didn't test the feed bags, they just got some figures related to the infants. And the whole point is those figures are misleading because we know about the way that neonates work anatomically, that it's just not the way that it was presented in court is absolutely guaranteed that this has to be an insulin poisoning, but that just isn't the case. And given all the other unlikely factors that I just mentioned, the hypothetical nature of it and the logistics and so forth, it's overwhelmingly likely that these readings, they're not even a direct measurement of insulin because that's not the way immunoassays work, and they couldn't directly measure the insulin in the bags because they didn't keep the bags because no one suspected anything. So the chances of that being correct are incredibly slim, but it can't be proven that they were accurate or inaccurate. We will never know whether these results are inaccurate or inaccurate because they didn't keep the bags. That's the only way of knowing for 100% certainty. Obviously, if you do the follow-up tests, that gives you a very, very great indication. And if there'd been follow-up testing as is required, and that had come up positive for everything, then we'd have to concede that Lucy's likely guilty. And I probably wouldn't be sitting here. But as that testing was not conducted, as the bags were never kept, and as all they've got is some figures that actually are not that unusual in neonates, and as there's a third insulin case that shows exactly the same pattern, there are serious question marks, and that's why have endocrinologists, you have microbiologists, you have chemists, all these people coming out and saying, look, this isn't acceptable. I mean, I've spoken to geneticists who said the same thing. There are numerous experts saying, look, this is not an acceptable level to convict someone. This is not proven. It's not the what was presented in court is incorrect. The way that it was presented in court is inaccurate, and this needs to be overturned. And I just don't think it's proven beyond reasonable doubt. In terms of it, we can never prove 100% that the infants were poisoned, and we can never prove 100% that they weren't poisoned. All we can say is that all of the available evidence points strongly to the fact that they weren't poisoned. We can't say with absolute certainty because they've thrown the bags away ages ago and we can't test them. We can't test the infants because they survived and there was no suspicions at the time and they weren't tested at the time. So I hope that answers your question. I don't really understand the pros and cons of quashing the conviction versus a retrial. Quashing would mean her immediate release, but the conviction is simply unsafe and she will not be proved innocent. So the pros of quashing the conviction would be Lucy wouldn't have to go through a retrial. Of course, as we've just seen, if there is a quashing of a conviction, the CPS can still try and retry the case. So if the cases were just quashed and there was no retrial, Lucy would just go free. You are correct that she would not have proved her innocence, but even if she's found not guilty, she will not necessarily have proved her innocence in the eyes of the law. The pros, obviously, of a court case would be it would all be heard, there would be big media coverage, and Lucy would be, in a sense, as you rightly put it, proving her innocence, or at least proving that she's not guilty. So that would be a pro. An obvious con would be that she'd have to go through the whole process of a trial over again. It would be incredibly nerve-wracking. And there's also the possibility she could be convicted on one case, even though she's, in my view, quite obviously innocent. So those are really the pros and cons. Retrial on all cases would mean she has a great chance of walking out completely innocent and a free woman. Would she be allowed out pending a retrial, or is she still in prison as a convicted murderer, or is she back on remand? How does the decision affect her right to compensation? So she wouldn't necessarily be allowed out of prison in the on bail if there was a retrial. I personally think this is unlikely. Morally and ethically, it should probably happen, but I doubt that it would happen. In terms of how the decision would affect her right to compensation, there's a very high bar for compensation. If Lucy Letby is exonerated on all cases, there is going to be enormous public pressure for her to receive compensation. However, I believe that she will receive stuff through Crown funding, and I mean, there's something I would like to do for her that would be lucrative for her if she wants to do it. I think that she can make millions without having to receive compensation, but she should receive compensation as well, of course, because there's no amount of money that can compensate for what she's been through. But I mean, I believe that when she comes out, she'll receive an enormous amount of public support. If a retrial is ordered, then could that be just for a few of the convictions? And in that case, what happens to the other convictions? So I've already answered this question. The answer is yes. The other convictions are just struck off and they go into the memory hole. They're just discarded. Could they find her innocent on some of the crimes, but not all of them, and she's still in prison? Yes. Such a split decision might be quite attractive to the Court of Appeal, as they might partly pacify the innocent lobby and save face for the law and the police. The things that worries me is this is all dependent on lawyers once again, none of whom has a clue about medicine. Well, I agree with your comments there. I don't think a partial exoneration would pacify the innocent lobby, and I don't think it would save face for the law or the police. I think it's possible that she could be retried on a few of the cases because they might think, well, we can't do the statistical case, we can't put the shift chart in court because it's going to be torn to shreds. Some of these weaker cases are going to be torn to shreds, and that's going to damage the stronger cases. But then on the other hand, you could say, if they don't put the cases in the court that they did originally, then the defence is going to say, well, originally they thought Lucy Letby was guilty of 17, was it over 20, 24 counts, was it? And they've thrown 21 of those out the case. So they're obviously not that confident. So it's a delicate thing for the Crown Prosecution Service either way, and who can tell what they will do? Who knows what will happen next? It's very difficult to predict, but it's certainly possible, as I mentioned, to just try her on some of the cases. Obviously, a kind of nightmare scenario is if she's cleared on 23 of the 24 counts and just loses one, in which case she'd still be facing a life sentence. Whether she would be eligible for parole under those circumstances and allowed to apply, the full life sentence will be struck off, I don't know. I mean, that'd be pure speculation. I'm not an expert on that. I don't know. But obviously, I believe she'll be exonerated and we need to work towards that. Regarding your point about people refusing to budge on their belief, a member of my family who I love and respect is reluctant to change their mind on Lucy's guilt, and their reasoning is that those speaking for her, such as David Davis, are Conservatives who want to dismantle the NHS. Now, I'm as big a cheerleader of the NHS as you can find, but even I can see that evidence is evidence, and there are systemic failings within our beloved health system. But this blinker of my family member is not unique, I don't think. There's this feeling of we can't undermine this verdict because it will destroy the public faith in the NHS, and then we'll lose it. So that's an interesting... It doesn't ask a question as such, but I wanted to address this. So, firstly, David Davis does not want the NHS to be dismantled, so that's an instant thing that you can say to your family member. David Davis will be a big support of the NHS. David Davis is very much working class. David Davis grew up on a council estate. He's a thoroughly down-to-earth gentleman and does not want to dismantle the NHS. I accept that there has been justified criticism of the Conservative Party in this regard, but I think that David Davis is certainly not one of those who is critical of or hostile towards the NHS. In terms of the general feeling, if we can't undermine this verdict, what I would suggest is, if we don't address this, then we cannot have a safe healthcare system because of the things I mentioned previously about Thirlwall and the fact that we're allowing major incident where there have been major failings on a neonatal ward dealing with vulnerable patients. There's obviously a problem in maternity in this country, that's very clear. We're allowing this to be brushed under the carpet, That's incredibly dangerous. That's dangerous for every single person in this country that has children, particularly young children, immediately. So we're undermining the NHS by not addressing this. And there is the chance and the possibility and the opportunity for, when Lucy is exonerated, for this to inform reform of the healthcare system, so that rather than destroying public faith in the NHS, I don't think that can easily happen because it's so ingrained in our culture, and it, as you rightly describe, it's a beloved part of our society. So I think only people want to know, how can we learn from this to make it better? So perhaps you could feed that to your family members, and perhaps they will be receptive. If I may ask, do you think the CCRC is or is likely to be pressured into stalling on Lucy's application? I don't think they're likely to be pressured into it, and I think they'll deal with it as fast as they can. It may not be as quickly as we would like. I think they will feel under pressure to make sure they assess the case very diligently, but I don't think they'll be pressured into stalling it. I think, if anything, the opposite is the case. Do you happen to know the exact date of the meeting with management and or the correspondence with management when one or other of the consultants first formally uttered words to the effect that they think Lucy Letby had been deliberately harming babies, as opposed to their initial vague innuendos at various times regarding her competence? So we don't know the exact first date because this is likely to have happened behind closed doors. We know that in July 2015 there were already explicit concerns on the unit, so it's very likely that at some point during 2015 there was a meeting or discussion with management. We're not privy to the precise date because we're not privy to everything that occurred. So all I've been able to record on the unit, recording videos, is what happened on the unit, and the only documents that I have are what's in the Thirlwall inquiry. So there's quite a long gap from July, then there's a bit of a gap to October, and then there's a further gap into 2016. It's clear that by the kind of midpoint or well into 2016, by the spring of 2016, there are very serious concerns, and they are speaking with management, but it could easily be that they spoke with management before then. Wasn't sure which video to write this question on, but do we know the dates written on the relevant handover sheets? If the dates precede the date of the actual death, then that would prove they're not trophies. Serial killers don't take trophies beforehand. So we do know that a lot of the dates are not relevant to the indictment. I obviously don't personally know the dates that are written on the relevant handover sheets because this is a very it's an exhibit in a court case, and obviously I don't have access to it. Very sensitive item. I've never heard the dates mentioned, so I don't think that information is publicly available. The defence didn't think to use it or didn't use it. I think the dates make it clear that most of the handover sheets have nothing to do with the case, which is obviously critical. I think the angle that you've mentioned here is a very interesting one, but we simply don't know that information. I wanted to ask about the allegations that Lucy was texting with Miss Griffiths about tips on how to get away with murder. I read an article about this on the BBC website. What are your thoughts on this, and if they are true? So this is total rubbish. This was a throwaway text message about where Lucy made some comment about getting away with murder that is obviously a joke. It really doesn't require or merit any further consideration than that. It's just a throwaway remark. She didn't give tips on how to get away with murder. She made one comment that's being taken out of context. It's just a joke. Quite obviously, there's nothing else to say other than that. It shouldn't be in the court case. It's total rubbish. Have you given any thoughts to the Hillsborough Law and its potential implication for Lucy's case? If you have, I would be interested to hear them. I have given some thoughts to this, and it's very interesting that this law has been passed. It's obviously been passed to ensure that a situation such as the Hillsborough inquiry, where the police have got off scot-free yet again, is not repeated in the future. I don't know about the dates, because the dates have been passed after the conviction of Lucy Letby, whether that means that the Cheshire Police, in the event of an exoneration, would be spared a proper inquiry and proper consequences, I don't know. Or whether it can be looked at retrospectively and they'll say, well, we passed the Hillsborough Law, that law is now active, so you've got to deal with it. You can't go and say, well, at the time we did this and at the time we did that, and the Hillsborough Law wasn't active. I'm not sure what applies. If the police can weasel their way out of it, they will, and they usually do. But I hope that they can be held to account. They weren't corrupt, and they're doing things now that I believe are in bad faith, but they did the investigation in good faith. They just did a very bad job. Same at Hillsborough. I don't believe the police acted in bad faith at Hillsborough. I mean, why would you? They don't want to see people die. They were incompetent. They're incompetent, not corrupt. At Hillsborough, and they were incompetent, not corrupt here. And I don't think they acted improperly, they just acted incompetently. I hope that they will be held to account for this, and I hope there'll be a very serious inquiry, and I hope that police constabularies all over the country will be educated about how to investigate cases. Whether or not that will happen in actual reality remains to be seen. We are told that the police have refused to investigate Brearey for 2 potential crimes because of the jury's decision to find Lucy guilty. Also, the shift chart and door entry date evidence used to convict Lucy is now proven to be false evidence. This false evidence could be viewed as police misconduct, and as the police won't investigate Brearey, would it be possible to start a private prosecution against him? So I don't want to go into all of the comments that you made here. I'll just address the final question about a private prosecution. So I was reading into this a little bit, and someone tried to make a private prosecution against Michael Barrymore. You may be aware that someone died at a party at his house, which is probably just a very unfortunate accident. He probably had nothing to do with it. But I think there were certainly questions of manslaughter because it was suggested that he plied people with drugs. I don't know whether or not that's true. Certainly eyewitnesses say that it is true, but whether or not it's true, I don't know. And they tried to launch a private prosecution against him. That private prosecution was completely unsuccessful. So I've not investigated this in great depth, but I know a private prosecution requires a lot of money, it requires a lot of effort, and I think the likelihood of being successful, if you can't launch a private prosecution against Michael Barrymore, launching one against multiple extremely powerful organisations that all stand to be hugely embarrassed by this is going to be very difficult. So I don't wish to discourage people, but I can't recommend trying to launch a private prosecution in this case, which will be extremely difficult, potentially expensive, will require a lot of support and may go absolutely nowhere. I have a question about the integrated system in the UK, where a concern about a child's death be centrally reported. I think it developed from social services lessons learned. So I'll look into this now and we'll just go over this briefly. So I think what you're referring to is the child death overview panel. I believe this is correct. So you can see one from Cheshire and Merseyside here. The child death overview panel reviews whether lessons can be learned from child deaths in order to improve the health, safety and well-being of other children. The key functions of a CDOP are to review all child deaths, excluding those babies who are stillborn, and planned terminations of pregnancy carried out within the law, determine whether the death was preventable, if there were modifiable factors which may have contributed to the death, decide what, if any, actions could be taken to prevent such deaths happening in the future, identify patterns or trends in local data and reporting these to the Safeguarding Children Partnership, refer cases to the Safeguarding Children Partnership chairs where there is suspicion that neglect or abuse may have been a factor in the child's death. In such cases, a child safeguarding practice review may be required, agree local procedures for responding to unexpected child deaths. So I believe that's what you're referring to. And there is a system in place, and I guess this is something that would have been used at the time or certainly should be. So which question did I get up to? This one. This conviction gets more disgusting with every video you post. 2 questions if you don't mind. Have you seen a single thing during your investigations to doubt Lucy's innocence? Also, are you still convinced that the 3 arrests at the hospital are management rather than medical staff? So I can answer both of those questions in one word. The first question regarding have I seen a single thing during my investigations to doubt Lucy's innocence, the answer is no. And are you still convinced that the 3 arrests at the hospital are management rather than medical staff? Yes, I am. Because it was mentioned specifically in the press that it was executives that were arrested, and the police are not going to undermine their own narrative that the because this ran all the way through Thirlwall, they were pretending that, oh yeah, and if only the executives had reported the case more quickly. So that's all a load of rubbish, of course. And regarding whether I've seen a single thing to doubt Lucy's innocence. I've been searching for it all the time I'm doing research. I kind of stopped now because it's very clear that nothing is going to come up. I've been researching this for over 2 years. It's just evident that there is nothing new. But I've constantly been looking out for a red flag. I just haven't seen one. There isn't one. Is it the case as suggested here that the team from the RCPCH who reviewed the unit were aware of Brearey's suspicions of Letby? So they were certainly aware of suspicions. Whether they were aware that they came from Stephen Brearey, I don't know. But it's specifically stated in the RCPCH report that they were made aware of these suspicions. And there is, in the redacted section on Lucy, they reference these suspicions. I still cannot fathom why Brearey became suspicious of Letby as a killer. Did he believe her Datix entries were a criticism of him personally, and he became irritated with her to the point he felt she was a threat to his position as head of a dysfunctional unit? It all seems too ridiculous for words. So I kind of addressed this earlier in the video. The reality is I don't have a good explanation for this question. It is something that troubles me and that I've pondered at great length. But I don't have a good answer to why he fixated on her so quickly. There are many possible reasons. There are many credible views on this. Datix can certainly be a contributing factor. I don't think there is one silver bullet reason. I think it's probably several contributory factors. And the reality is we may never know. He maybe doesn't even know. I cannot give you an absolutely cast iron reason. It can be due to concerns about past serial killer cases, due to Datix, as you mentioned. Is obviously a very self-serving view. I've got this quote in my book about how views can gain momentum when it's a self-serving view and people all get together and they all share the same perspective, etc., etc. It can be all of these things together, and it can be other things that we haven't thought of. I ultimately just do not know why this happened. Chris, Lucy is very fortunate to have you devoting so much time and effort to research, let alone writing and voicing video production. She also got Dr. Shuley and the par excellence team he got together. We now know Letby is no more likely to have killed a neonate than any other neonatal nurse across the whole of the NHS. It's not just an unsafe conviction, but there is actually no reasonable evidence upon which to have initiated a police investigation in the first place. Evidence was key to this going any further than the first month. The judge blocked the RCPCH report from evidence. It's impossible to explain legally and certainly medically. The same judge was directly warned off Evans by another judge, which in and of itself is extraordinary. The multi-institutional irreparable damage to Britain as a whole goes far, wide and deep. NHS medical specialist doctors, medical expert system, police, lawyers, particularly Crown prosecutors, who have a key responsibility to justice and not merely winning cases, the judge and the judiciary more broadly since, and the media, my God, the evil legacy media. There are no adequate words to fully elaborate the nature and consequences of this catastrophic mess. Was Dr. Brearey just deflecting because he made errors? His actions caused more than just raised eyebrows. So this is very much related to the previous question, and I wanted to read all this out because I believe this came from an expert witness who posts. So I largely agree with all the comments, and there's certainly comments about the legacy media are not entirely unreasonable. What I will say is that this case has given me a little bit of faith in journalism, because there have been some very commendable journalistic efforts from Clersey, from Anouk, from Sarah Napton, from Felicity Lawrence, from David Conn, from Philip Hammond, even from Peter Hitchens, from proper, credentialed, conscientious journalists, and in the Mail on Sunday as well, and in the Sun. I mean, it's been quite incredible, actually, if you look at it. I mean, I feel less hostile towards the legacy media than I did previously, to be honest, but I do understand your point. In terms of whether Dr. Brearey was deflecting, this is another possible explanation. I don't think it's that simple. I don't think Lucy was deliberately scapegoated in the way that they deliberately targeted her, as I've said previously. That may have evolved, that position may have evolved as time went on, but I think initially there were genuine concerns about the unit, genuine concerns about deaths. As to why Lucy was inadvertently scapegoated in the way that she was, I have absolutely no idea. It's just absolutely crazy. It's very regrettable, and it will be written into British history eventually. Thanks for all your research. Your evidence shows that those managing and the doctors and nurses knew that the hospital's performance was way below any acceptable medical standard. Did the executive level just ignore all the reports highlighting the shortcomings and the doctors and management reports asking for more staff, etc.? So certainly those managing and working on the unit should have known the hospital's performance was not acceptable and that conditions on the unit were not acceptable. The executive unit did not ignore them because they were well aware of the RCPCH report. They interacted with RCPCH people that were there from that organisation to assess the unit. They interacted with Dr. Jane Horden. They were aware that mistakes were made. They were aware that there were problems on the unit. I don't think it's correct to say they ignored them. I think they were in a very difficult position, and I think they dealt with it reasonably professionally. Some people in the comments have been critical of the executives for failing to deal with the problems on the unit, and people have highlighted that there are certain systems and procedures in place to ensure that the executives know, and that they should have enacted those systems and responded on them. And I'm not in a position to say that's anything other than correct. I don't know. I think running a hospital is a very difficult job, and you are to some extent reliant on the consultants and people on the units being your eyes and your ears if you're working at the executive level. And it's clear that the consultants may not have passed things on to them that they should have done. Certainly, once sewage was leaking around on the unit, it should have been closed immediately, and this probably never would have happened. But it's not true to say they ignored it, but perhaps they didn't act on the concerns, or perhaps they didn't act on the reports, and perhaps they didn't identify the problems with a level of competence that they should have done. And perhaps they could have acted differently, and perhaps a different executive body would have acted differently. I have great sympathy with the executives because of what has happened to them and because of the way that they're being blamed for it, and blamed for the situation with Lucy, which I think is outrageous because they couldn't possibly have done anything different. And they ran they dealt with the very delicate situation with Lucy very professionally, and they did a grievance procedure, and they got the main bodies in, the RCPCH and others, and they acted on those reports, and they got a neonatologist in, and they got coroners, they got pathologists, they had stuff reviewed by Joan McPartland. A lot of what they did was very good. They may have made mistakes, but we're all capable of making errors, just as the doctors on the unit can make errors. Now, it is clear that the doctors have made negligent errors, and they should be facing serious consequences for that. But I still always try not to be too hard on them in terms of medical errors, because I'm not a medic. I've never been on a neonatal unit. I've never been in a life or death situation where I have to do something to save someone's life. So I always try to take that into consideration. I also think there are people, the very few number of people that still obsessively post about Lucy being guilty, they are extremely unfair and unbalanced in their views, and they say all kinds of things that they're not qualified to say, despite the fact they have no qualifications, credentials, experience, etc. So I try to be very careful not to do that. And obviously I'm not qualified to run a hospital on an executive level. I may be good at it if I was trained and if I practiced it. I don't know. There were shortcomings, there were mistakes from the executives. The consultants, I think, didn't behave professionally, but it's not fair to say they ignored all the warnings, because they may not have received all the warnings, even though they may not have got things 100% correct. In your investigations, you have mentioned doctors doing 2 ward rounds per week, when it appears 3 ward rounds per day is normal practice. I just wonder what the reason was. Did they work somewhere else? So we don't know the reason. We know that staff were spread thinly and they were dealing with a maternity ward as well, but there simply is no excuse for this. This is in the RCPCH review, and it just shouldn't happen. It's as simple as that. Ask anyone with any paediatric or neonatology experience at any level and they'll tell you the same. I have a question. I read recently that the defence and prosecution had a pre-trial meeting with medical experts and a judge where they all agreed, including Myers, that 2 of the baby's deaths were unlawful. Why was the decision made at a pre-trial meeting, which meant the court, and specifically the jury, wouldn't have heard or seen the evidence that showed proof of unlawful killing? And is that common in cases as momentous as this? So I'm not quite sure what you're referring to by the unlawful deaths, but it is common to have a pre-trial meeting. That's normal practice. There are several reasons for this. It can be to do with scheduling and the management of cases. It's obviously important to clarify the issues involved. There can be situations where there's a settlement and where it's clear it can be resolved without going to court. It's necessary for reasons of disclosure. There are procedural directions sometimes that are necessary. And There also, bear in mind, this court case went on for 10 months and there were all manner of frivolous things brought up. Imagine if some of those things were eliminated. So this court case could have gone on for over a year. This was longer than O.J. Simpson's case, for example. This was an enormously long court case and it was completely unjustified. So there is some justification for the two parties getting together and eliminating certain items of evidence. And also there needs to be, because there's disclosure, there needs to be disclosure. So you can't have a situation where the defence goes in blind or the prosecution goes in blind, because then you literally wouldn't know what the other party was going to say. There has to be the opportunity for the defence to prepare its case. So that is kind of the point of the pre-trial meeting. In terms of what decisions were made, the prosecution and the defence have to act in their own best interest or what they believe to be their own best interest. So that's essentially why those decisions were made. Thank you for your analysis. Do you think there will be wholesale reform in adjudicating scientific medical cases in the future? What is so disheartening is the CPS disregard of the Law Commission 2011 guidelines and recommendations for the use of expert witnesses. Evans was retired for many years and was not even a neonatologist. They disregarded opposing expert opinions such as Professor Hutton is. If the CPS had followed the Law Commission's guidelines, this awful situation could have been avoided. It appears even if safeguarding measures regarding expert witnesses are implemented, the CPS just ignore them. What will it take for legal reform in medical scientific cases to be properly implemented? Some very good observations and questions there. So let's look at the Law Commission guidelines first. So when Lucy's exonerated, I think it's very likely that these will be enacted. They should have been enacted before now. And Sir David Davis will have quite a lot of leverage. He's already mentioned this. It's already well known. Of course, we're talking about it now. It's been in the private eye. I think it's very likely that these guidelines will be enacted. In terms of whether there'll be wholesale reform in adjudicating scientific medical cases in the future, I have to be cynical and say, no, I don't think that will happen immediately. As I've mentioned earlier in this video, I will work in this space for the rest of my life, and if I get a bit of a voice, then I'll use it, and I will do what I can to ensure that people understand that the system cannot deal with scientific and medical cases. But I also know that there's always a determination in this country, and probably many other countries, to sweep things under the carpet and say, we've got a system, reforming the system is too difficult. It's the same thing as kicking the can down the road. This is an expression that's often used. Let me give you an example of where that occurs. It occurs with regard to debt, government debt. So recently we've just seen a situation where the United States closed down its government. This is appallingly, abysmally reported generally by the media. What it means is that it's not about an argument in Congress or an argument in the Senate. What it actually means is that the US government can't fund its basic services without borrowing money. And it's currently borrowing $2 trillion a year. And it's currently astronomically in debt. There's a very old clip from before he died of about 1993 of Bill Hicks being interviewed by Jonathan Ross on Channel 4. And Bill Hicks is talking about how people's eyes glaze over when they hear about a debt of like a few $1 trillion. So at the time that was deemed a lot of money. I remember when $10 trillion, I remember when there was a clock on Wall Street in 2008 roughly, and they couldn't display the US government debt of $10 trillion because they'd run out of digits. Now, let me just bring it up on here to see what it is now. I think it's like 50 trillion or something. But let me just bring it up so I can be accurate. No, it's not that high. It's 37 trillion. So at the moment, US national debt has increased nearly fourfold since 2008, 2009, when the Wall Street clock ran out of digits. So it's now not $10 trillion, it's now $37 trillion. Unfunded liabilities are insane. But anyway, this podcast not about economics. But they'll just kick let's just borrow more money, let's just do this, do that, we'll do a bit of quantitative easing, we'll close this government department down, we'll move this around, we'll move that around, there you go, that's fine. Oh look, the budget deficit's only $1.897 trillion now, that's great, we'll just carry on. So this time next year, I can see it going up now, it's already gone up a million to a couple of million just the time I've been talking. So pretty soon, like currently, as it stands now, this time next year, it won't be 37.8 trillion, it will be 39.7 trillion roughly. So that's an example. Same situation in Britain, same situation in many other countries. So what we're great at doing in this country, and what other countries are great at doing at as well, generally there are very few countries that don't do this, is just saying, oh, we've got a system, the system works, rich people are rich, everything's absolutely fine, let's just continue the way we are now. And I don't think there will be wholesale reform immediately, because I don't think... I mean, come on, you look at the political leaders in this country, there's Keir Starmer, there's Kemi Badenoch, there's Nigel Farage, I've forgotten the leader of the Liberal Democrats is now. Do you really have any faith in any of these people to grasp the nettle and make the kind of wholesale reform? Do you think they even have the kind of scruples required to do that? I don't have any faith that'll happen. And in answer to the final question, I think it'll take an enormous amount of pressure from people over a period of time, as indeed all reform does. Did the consultants have an appraisal system in place? They certainly didn't like criticism. So we discussed this actually with the radiologist I interviewed. He was particularly citing the appraisal system and the fact they didn't appear to get any appraisals at all. So yeah, it seems that something went very, very wrong on this neonatal unit with regard to appraisals, which is an interesting point because it's not something that I would have picked up on. And finally, who was responsible for acting on the suboptimal care status of the clinical reports? So ultimately, that is the job of the executives at the hospital. It should be a job for people working on the unit. Clearly, if there's suboptimal care, that should be highlighted by the consultants. There should, in effect, be a joined-up process where people working clinically and those working in an executive administrative capacity are connected, and they are able to identify these issues and then address them. And that's what will happen in a competent unit and a competent hospital. It's clear there's a massive disconnect here and things went very wrong. But ultimately, the ultimate responsibility is with the executives. As we know, and as I've discussed in this video, there is something of a power play in many hospitals whereby the executives don't have half as much power as they should, because they are ultimately responsible. So therefore, they should at least be equal to the consultants and certainly, in my view, above them. Now, it's interesting that Dr. Evans has crapped on numerous times about how the executives have all the power and the consultants should have the power. Absolutely not. The consultants have too much power now. The consultants are almost completely unaccountable now. There is no doubt that there should be executives above consultants acting on the unit, because otherwise the consultants are a law unto themselves and they can just do whatever they want. They can make massive mistakes. There could be suboptimal care. Who are they accountable? If they have more power, who are they accountable to exactly? They can just do whatever they want. It's an absolutely ludicrous suggestion that there shouldn't be. There has to be administrators. There has to be executives running the hospital. We can't expect clinicians to run the clinical care in the hospital and run the administration of the hospital. Clearly, there needs to be executives and administrators, and they have to be above the clinical staff. They have to have some jurisdiction over the clinical staff. To suggest otherwise is just ludicrous. So ultimately, it's the executives that are responsible. They are held responsible, and that's why they're facing the arrest that has occurred and potential charges for malpractice. I've forgotten the precise charges it is described, but that's because they are ultimately responsible. So that answers all your questions. I hope you've enjoyed this video. I'll just have a quick finish because I realise it's been a long video, but I try to answer everything thoroughly. So if you have any comments, if you'd like to like the video, if you'd like to subscribe to the channel, if you're not subscribed already, that would be greatly appreciated. My next video, as I mentioned, will be on the timeline. It'll be the third part of the timeline on the police investigation. Thank you very much for watching and for all the support. It's very much appreciated, and I'll speak to you all again soon.